top mistakes that I see with trust-based estate plans. Hi, I'm Alec Osland. I'm an attorney at Yanowitz Law Firm, where we've been helping families for 30 years with wills, trusts, and probate. Now, I review a lot of trusts. And that being said, I see a variety of problems and issues with a lot of trusts and other estate planning documents. But these are the most common mistakes that I see when I'm reviewing trust-based estate plans. The first is, and this is probably the most common, not everything is funded correctly. This is very important. All right. So generally speaking, when we're doing a trust-based estate plan, one of the goals is we are trying to avoid probate. Very regularly, I have to help clients who worked with another firm, and we have to go through probate even though they had a trust because the trust was not funded correctly. A lot of people think, I signed my trust, that's it, I don't have to do anything, and they never follow up with updating their beneficiaries designations. They may never retitle any of the assets into the name of the trust, so they don't actually fund the trust, and it's almost useless because nothing was in the trust or direct to go to the trust. So it's very important that when you have a trust, it is funded correctly. So for example, with our clients, we actually give letters and instructions on how everything should be titled, how the beneficiary should be, to make sure that the trust is funded correctly. It's also important that if you open new accounts in the future, that you verify how that asset should be titled for what makes the most sense to align with your estate plan goals. Now, another issue that I see is almost the exact opposite of the first one. So instead of not funding it correctly, they essentially almost overfund it. And what I mean by overfund it, they essentially put everything in the name of the trust. Now, this is not something that we generally want to do. Depending on the type of asset, we may not want that asset in the trust. And that may be for tax reasons or other reasons, but generally speaking, it is not advisable to just put everything in the name of the trust. Again, this is why when we work with clients, we prepare those letters telling them exactly what to do with each asset and how it should be titled. Because like I said, there can be major tax implications if something is titled incorrectly. Another issue that I see with trust-based estate plans is kind of just a misunderstanding. I have a lot of people that I speak with who thinks that the trust protect them from liability, that they're kind of protected from creditors. So revocable trusts that you set up, those are revocable, meaning you're in control. You can move those assets in and out. You can change the trust at any time. So they don't offer really any liability protection. And I think there's a misunderstanding in the public that, I can put stuff in my trust and then I'm protected from creditors. And that's not the case. Now, I will say if you set up a revocable trust for the benefit of your children for when you pass away and they inherit those assets in trust, while those assets are in trust, those assets are protected then from your children's creditors. But if once those assets then are distributed to your kids, that protection isn't going to follow. But generally speaking, the revocable trust that you set up for yourself and maybe a spouse, you're not going to have that liability protection that a lot of people think you have. So if you set it up for someone else, those individuals are going to have that protection while that asset is in trust. My advice, if you're worried about liabilities, is generally always to an umbrella policy, but that's going to be something to speak with your agent about on that. Another issue that I see is that I see a lot of trusts that are poorly written. And now this may not be the fault of the client or the person whose trust it is. If they went to an attorney and an attorney did a bad job, it's not on the client to know what a trust shouldn't say. That being said, if they downloaded it from a website online and didn't actually meet with an attorney, well, that's on them. But I see a lot of trusts that are really poorly written, are pretty bare bones, and are missing a lot of provisions that we want, that may not have any credit shelter language in them to protect from state taxes, whether that's federal or state. Maybe doesn't kind of get into specifics or is kind of ambiguous. So I see a lot of trusts that are really poorly written. And when something is poorly written, that means there's ambiguity. People get upset and don't really know what direction to go. And maybe we have to have hearings on it. And then it gets really expensive. And the cost was tenfold what the person tried to save by trying to go the cheap route and not meeting with an attorney. So like I say, I see a lot of trusts that are poorly written, and that causes a lot of issues. One of the final mistakes that I commonly see is the approach of, I have a trust and I'm done. It didn't do any of the other really ancillary documents that go with a will or go with a trust, where the thought is, oh, this is all I need. With an estate plan, you want to have a will, you want to have a trust, you want to have a power of attorney, you want to have a healthcare directive. You want to identify what happens if you become incapacitated, or what happens if you can't make your medical decisions. If you have real estate, you want to make sure you need to record new deeds. There's a variety of ancillary documents that go along with any estate plan. And a lot of times I see a lot of plans are lacking these documents that we want to accompany the trust based estate plan. So I think in general, the key to avoiding all of these issues is you need to work with a law firm that knows what they're doing. When you go through that intake process and meet with the attorney, you want to make sure that you're comfortable. You want to make sure that they know what they're talking about, that they're knowledgeable. An attorney should be asking about all of the assets that you have, should be finding out what your goals are with your estate plan, and should go through a variety of different questions and different scenarios and hypotheticals to figure out what is the avenue that best allows you to reach your goals and accomplish everything that you want. When we meet with clients, we have them fill out an intake form that is pretty precise, and we usually spend a decent amount of time kind of walking through that intake form. We have a variety of other questions. We go over every single asset they have. We make instructions on how every asset should be titled, of updating beneficiaries, making sure that we're going to not just accomplish all the goals that they have, but we also want to make sure that you're giving them the best tax treatment as well with everything. It's very important that you meet with a law firm and work with an attorney and make sure that your plan doesn't have one or multiple of the mistakes that I regularly see. If you're interested in finding out more about estate planning, make sure you subscribe to this channel to find out when we post a new video. Thanks for joining me today, and have a great day.